Of the Metropolitan Area Planning Commission. Can we have our public announcement, please?
Before we begin the agenda, the Wichita-Sedgwick County Metropolitan Area Planning Commission and the Wichita-Sedgwick County Board of Zoning Appeals would like to take this opportunity to welcome everyone to this public hearing. Copies of the agenda for today's meeting, the public hearing procedure, and Planning Department staff reports on all agenda items are available in the lobby of this conference room. The Planning Commission's and the BZA's bylaws limit the applicant on a zoning, subdivision, or variance application and his or her representative to a total of 10 minutes of speaking time at the start of the hearing on that item, plus up to 2 minutes at the conclusion of that hearing. All other persons wishing to speak on agenda items are limited to 3 minutes per person. However, if they feel that it is needed and justified, the chairman may extend these times by up to 2 minutes. All speakers are requested to state his or her name and address for the record when beginning to speak. When you are finished speaking, please write your name, address, and the case number on the sheet provided in the lobby. This will enable staff to notify you if there are any additional proceedings concerning that item. Please note that all written and visual materials you present to the Commission and the Board will be retained by the Secretary as part of the official record. If you are not speaking but you wish to be notified about future proceedings on a particular case, please sign in on that same sheet. The Planning Commission and the Board are interested in hearing the views of all persons who wish to express themselves on the agenda items. However, we ask that all speakers please be as concise as possible and avoid long repetitions of facts or opinions which have already been stated. For your information, the Wichita City Council has adopted a policy for all city zoning items. A copy of this policy is available in the lobby. The City Council relies on a written record of the Planning Commission hearings and does not conduct its own additional public hearings on these items. The decision of the BZA is final. Any appeal of a decision of the BZA is to district court.
Okay, our first item of business today is the approval of the January 23rd minutes of the MAPC.
Move we approve the minutes.
Motion by Mr. Hartman, second by Mr. Nix. All those in favor signify with the up raised hand. Motion passes unanimously, 11-0. We will see which items we can take by consent. Item 2.1, a one-step final plat, Premier Landscape Edition, located near East Pawnee Road and South 159th Street South. Is there anybody on the commission like to hear that item? Seeing none, is there anybody in the audience that would like to hear that item? Seeing none, we will take that by consent. Agenda item 2.2, one-step final plat, Passageways Edition, located near west of South Seneca Street and West MacArthur Road. Anybody on the commission wish to hear that item? Anybody in the audience wish to hear that item? Seeing none, we'll take that by consent. Agenda item 2.3, one-step final plat, Copper Fox Edition, near East 63rd Street South and South Hydraulic. Anybody on the commission want to hear that item? Anybody in the audience wish to hear that item? We will take that by consent.
Move we approve items 2.1, 2.2, and 2.3.
Motion by Mr. Green.
Second.
Second by Mr. Johnson. All those in favor with their upraised hand. Motion passes unanimously, 11-0. Public hearing items. Agenda item number 3.1 has been deferred to February 20th. Public hearings. Agenda item 4.1, city zone change from SF5 single family to a planned unit development west of North Maze Road and West 21st Street North. Anybody in the commission wish to hear that item? We will hear that item. Agenda item 4.2, zone change from SF5 single family to general commercial near South Seneca Street and West 63rd Street South. Anybody on the commission wish to hear that item? Anybody in the audience wish to hear that item? We will take 4.2 by consent. Agenda item 4.3, city zone change from LC Limited Commercial to Office Warehouse near South Hillside and East 31st Street South. Anybody on the commission wish to hear that?
Mr. Chairman, I had a staff question on that item.
Okay. Anybody on the audience want to hear that item? Okay, we'll come back to that for a staff question later. Agenda item 4.4, city zone change from single-family residential to two-family residential near West 9th Street North and North McLean Boulevard. Anybody on the commission wish to hear that item? Seeing none, anybody in the audience wish to hear that item? We will hear that item. Agenda item 4.5, a city zone change from SF20 single family to general office near West 53rd Street North and North Meridian Avenue. Anybody on the commission wish to hear that? Anybody in the audience wish to hear that item? We will hear that item. So the only one that I see on consent on that one was agenda item 4.2. Is there a motion?
Move to approve.
Have a motion by Ms. Miles. Who was the second? Mr. Florence. All those in favor of that motion signify with the upraised hand. Motion passes unanimously at 11-0. Before we go hear the items, we'll get the question out of the way. Agenda item 4.3, zone change from light commercial to office warehouse. Mr. Foster, you want to ask your question, please?
Philip, if you look at the site plan under its notes for the landscape buffer, it states required at west property line between SF5 and OA zone properties. What is OA zone property?
It's probably a typo. It probably should say OW. The request for this subject property is to go from LC to OW.
Okay, I just
And
wanted
so
to make
it
sure.
probably needs, that was something I didn't catch, but thanks for catching that. We'll make sure he gets a revised site plan with that correction.
That was my question. Thank you.
Okay, with that question out of the way, is there a motion on that item? Take that by consent.
Second.
Motion by Mr. Richardson, second by Ms. Miles. All those in favor of that motion signify with the upraised hand. Agenda item 4.3 is approved 11-0. Now we will go to agenda item 4.1, zone change from SF single family to planned unit development. Go ahead, Philip.
Good afternoon, Philip Zievenbergen with planning staff. Before I get into the staff report, you have at your table a paper-clipped packet for this case, some supplementary additional information for you to review. The first one is updated general provisions in response to a recommendation from the District Advisory Board this past Monday. I'll go into what those are. There's some highlighted text throughout this supplemental, so it does differ than what's on the attachment to your staff report. Again, it was in response to a recommendation from the District Advisory Board. The second sheet you have is the DAB report itself, outlining what the discussion was and some of the concerns raised by neighboring property owners. I believe we'll probably hear what some of those concerns are today during the public hearing of it. And the final one is a comment based on the access easement that supplies this property with access. It's by the applicant's attorney. This, I believe I emailed out to you earlier for your review, considering its length, but that's just a hard copy for you for your review. Again, it's from the applicant's attorney regarding the access easement going to the property. So getting into the staff report, this is PUD 2019-13. It is a request to rezone a subject property that's currently SF5 single family to PUD planned unit development. You can see here on the zoning map, its location. It's about a quarter mile south of West 21st Street North, about 450 feet west of Mays Road. If we go to the aerial image here, this is Pathway Church. Mays Road is up here with its kind of commercial corner. There's a subdivision down here. These are an orthodontist and a dentist office. This is the former Kirk excavating site. So that's the general location. The purpose of this PUD is to establish the DOBA development commercial PUD to facilitate existing commercial uses that are on the property. This was previously heard at the Planning Commission on November 21st of 2019. The will of the board at that time was to defer this case to provide the applicant and surrounding property owners time to potentially reach some compromises based on some of the discussion that happened at the Planning Commission. So we're hearing it back today. The uses that are on this property are a mix of commercial uses that just don't fit well into a specific commercial zoning classification, and this is why they're pursuing the PUD. In general, it houses a pet waste removal business. They primarily office there and store their work trucks there, so employees come in, pick up their trucks, go out, do their business. They dispose of the pet waste off-site, and then they bring their trucks back at the end of the day. A vehicle repair and refurbishment business. This is primarily for refurbishing golf carts. They've also worked on party buses. A construction business, outdoor storage business, and outdoor storage of personal property. So RVs, boats, other recreational vehicles, and other property. The full text of the PUD you have attached to staff report in addition to the updated text that I provided at your table. I'm going to go through some of the background, again, just to kind of remind us, since it's been quite a while since we've heard this case, to remind you of what's all going on here and what the general provisions are like governing this site. And along the way, I'll go through what the revisions have been since the last time we heard it. Overall, the base zone that this PUD will reference to is OW Office Warehouse. Within that, though, there's a list of uses that are going to be prohibited on this site. The only addition here is that in the intervening time from the last Planning Commission meeting, the applicant has added dry cleaning services to the list of uses that will be prohibited. In relation to the uses that are permitted by right, in addition to those in the OW district, there is no change there in terms of what uses are there. However, at the District Advisory Board meeting on Monday, the recommendation from the District Advisory Board was to approve this. It was a unanimous vote, 8-0. However, they attached two conditions. One was to omit a couple of the uses in there for concern of the future use of the property. One of those was vehicle sales. The way it's written right now and the way it's allowed and within our code, should it be the will of the applicant or if this property were to change hands, somebody could open up a car lot on this, and that was concerning to the District Advisory Board. So they moved to omit or to even provide just more specific clarification as to reducing the effectiveness of that use to maybe just tailoring it to what exactly they're doing right now on the property. The other one is the duplex uses. And that was their primary concern was if duplexes were developed here, you would have a significant increase of traffic along this access road, which is a private drive that this property owner to the east owns and is the sole responsible person to maintain it based on the agreement for the access easement. So that was a recommendation out of the board. In the packet that you were provided today, the applicant did provide some response to that. Instead of omitting those uses, they just got a little bit more restrictive with them, saying that the outdoor vehicle sales, you could not have any exterior display of the vehicles. And regarding duplexes, they said it would only be permitted if a second access point was allowed on the site. So this wasn't necessarily a specific thing that was stated in text, but you could imagine they could get permission from the Pathway Church property to have a second access point somewhere on the north or maybe here on the west side would be an example of when they could allow duplexes to be developed. So those were the responses. They did not necessarily agree with the full recommendation of the District Advisory Board, and I'm sure they will address those points when they get up to speak after me. Other things that were discussed at the last Planning Commission was the idea of a paint booth with the refurbishment business. They may want to do some of their own body work and painting on site instead of having it shipped off. And there was some discussion and concern about what kind of impact that would have with the residential properties nearby. In addition, the church has a daycare on the south side of the property, so there's discussion on that. The applicant did provide revised language saying that a paint booth would have to adhere to all federal, state, and local requirements, understanding that those are set in place to mitigate any hazardous effects of nearby property whenever there's a paint booth. Regarding landscaping and screening, overall, the original text requires a 6-foot screening fence on all 4 sides of the property. There are portions of the property, as you're going to see in the pictures here, especially on the west side, where that 6-foot fence either doesn't exist right now or it's in disrepair and has fallen down in some locations, so that would have to be put into place. The district advisory board, part of their recommendation was to put an 8-foot fence along the south and the east property lines, knowing those are the closest to the residential properties. The applicant, in discussion with them between then and now, disagree with that as well. They'd like to maintain the 6-foot fence, but potentially just, follow the fact that there's going to be landscape screening, landscape buffers in addition to that 6-foot fence, which are already listed in the provision document. That screening overall on the south side, there's going to be a 10 to 20-foot landscape buffer with a mix of deciduous and evergreen trees spaced every 10 to 20 feet. An amended screening plan for the east, north, and west side is to have a 10-foot buffer with trees spaced every 30 feet, a mix of evergreen and deciduous. What's amended is it actually increases the amount of landscaping that's on the east side. The original text states a 40-foot spacing of the trees, and the amended language has them spaced 30 feet apart. There's a standard lighting language in terms of the restrictions on height and shielding to avoid light pollution. The building setbacks, there's 35 feet on the south, 10 feet along the north and the east sides, and then on the north and the west side, and on the east side, it's a 30-foot setback, understanding that this building right here would be encroaching in there. Staff is aware of that, staff understands that, and that would be the sole exemption from that setback. Any new buildings built in the future would have to adhere to the setback. There'd be no outdoor speaker systems permitted. Building signage are limited to no more than 10 feet off the ground, and they're not able to have any internal backlit illumination. There's no electronic display signs allowed. There's architectural restrictions, making sure that everything has a cohesive development and looks next to or near in character with buildings that are on the site. And a drainage plan would have to be submitted to the City of Wichita for review. One other piece of clarification with this is that this property does not have to be platted in order for this zoning to be perfected. However, if they would like to build an additional building on the site and seek a building permit, it would have to be platted at that time before they would get a building permit. So that's kind of the overall thing. I believe I captured where we kind of been, what the revisions are up to this point in time. A couple clarifications or just review. At the Planning Commission in November, the members of the public spoke with concern of noise, odor, and compatibility of uses. One of the chief concerns was the traffic on the access drive, not only the amount and the potential future maintenance of it, knowing the property owner to the east bears a sole responsibility for maintaining it at this point. But also there was an indication, there was a specific incident cited where the gate to the property was not able to be opened. There was nobody that opened there, and traffic had backed up along the property, basically landlocking this property, and the owner, nobody in the household could get out or in from the property because there was cars backed up. Regarding the gate, there is no new language in the PUD document addressing the concerns about the gate. However, the applicant has installed an automated gate since the last Planning Commission as an attempt to mitigate any of those future issues where now people are issued a code, they can go to the gate, they can punch in the code, and the gate will open automatically for them. I have spoken to the property owners to the east saying that they have had an instance where either the code was changed or this person wasn't issued a code and that they were parking in the neighbor's driveway. So it's not necessarily a perfect compromise here, but the applicant is hoping that that was something that they could mitigate some of that traffic issue on the driveway. I'm going to spend just a small little note on this third paragraph here related to the possible error on the zoning map back in 2006. One of the city council proceedings for a previous zone change request mentioned that there was a misunderstanding or a misconception that somebody was of the understanding based on an error out of the zoning map that this property was zoned GC, general commercial, based on a map from 2000. This is a slide from our records back in 1999, which would have been the same zoning map they were referencing in that 2006 proceeding. This is the subject property here. You can see it's the same color as SF5, single family. So that just kind of clears that up, as nobody back then was able to produce any evidence that that error existed. Our records show that it was always zoned single family. It does have a conditional use on it, which we'll get into when we get to the case history. Regardless, with these being new owners since then, even if there was an erroneous error on the map, It doesn't actually apply to this property. It's a new owner. Due diligence should have been done on whether or not these commercial uses should be permitted on the site before they used them, and confirming what the exact zoning is on the site. Properties around this, as you can see, everything immediately abutting this property is zoned single-family SF5. As we mentioned before, there is the residence here on the east. There's several residences on the south, the church property to the north. The church owns this property that's vacant to the west. And then right along Mays Road, these properties here are neighborhood office and they're medical buildings. The case history with this, the conditional use that was back in 1974, allows a medical agricultural storage building used for the storage of alfalfa hay, farm equipment, and non-agricultural storage, including earthworking equipment, including trucks, tractors, and miscellaneous. That conditional use is still in effect today. It did not have any date to which it expired, so those uses could be used currently even if this zoning does not take effect. This site has gone through two separate zoning tries. Both were approved by Planning Commission and City Council. One was in 2005 for a PUD. The other one was in 2009 for neighborhood office. Again, both of them were approved by City Council with the caveat that the land had to be platted within 1 year. The land was never platted and the zoning was never perfected. So that's where we are today with it still being zoned single family. Staff is recommending approval of this with the following findings. We talked about the zoning surrounding it. Though it's all single-family SF5, it does have the conditional use for kind of intensive commercial type business on the site existing. The site is suitable to remain single-family SF5. However, if you're going to do more than just one single-family home, the more homes you're looking to put in there to make it economically beneficial to the owner or developer, it becomes very difficult. Just with that access drive, as we mentioned before, just really provides some constriction, especially considering the two previously successful, almost successful rezoning attempts for a PUD and a neighborhood office. The application we have before us today for a PUD is not unreasonable. With the PUD document and the guiding factors regarding the screening and the landscaping and the setbacks that will govern this site, staff believe that those will be effective enough to mitigate any possible detrimental impacts to surrounding property owners. Related to the comprehensive plan, you can see here on the land use plan for the 2035 future growth concept map that this area is identified for new employment that basically constitutes concentrations of manufacturing, warehousing, distribution, construction, research, business services, and corporate offices. With Mays Road being a 5-lane paved arterial road, other than the access easement, that road is sufficient. There's not going to be impending detrimental impacts to public facilities. As I mentioned before, it was heard at DAB on Monday. They did vote approval 8-0 with the two conditions to have vehicle sales and duplexes omitted, as well as the institution of an 8-foot fence on the south and east property lines. You do have the DAB report in front of you illustrating the comments from the public. I'm not going to delve too much into those as several of those same members of the public are here, and I'm sure they can convey their concerns a whole lot more accurately than I can. Let me take a moment just to remind us of what the site looks like. I've got several pictures here that were taken in November. This is at the entrance gate looking to the northwest. This is an office building. This is a building where I believe they do the refurbishment of the golf carts and buses. This is at the access gate looking due north. This is the property owner to the east. Coincidentally, this house actually used to be part of the whole property. It was actually split off and sold a couple decades ago. So this is that east property line. You can see here the screening fence stops and there's chain link after that. That would have to be amended and created into a screening fence in order for this zoning to be effective. Here I'm on the southwest corner of the property line looking to the northeast. There's the office building. This is that building I referenced related to the golf carts. This is where some of the personal property is stored. You can see some RVs and boats in there. This is looking to the south property line. As you can see, there's some holes in the screening fence there that would have to be fixed. I believe it's the will of the applicant to probably just put a brand new fence up. Just with the age of the fence and its condition, it would just be more effective to put a brand new fence up anyway. I'm on the church property in this drive looking to the southwest. This is that storage building with the personal vehicles. This is that vacant land that the church owns. Back on property looking to the east, that's that portion of the fence that does not meet code right now if it were to be a commercial property. And this is looking due east along the access drive towards Mays Road. You can see that it is gravel. For the majority of it, I think once you get closer to the medical offices, there is some pavement at that point. Back outside of the property, this is the west property line looking at it again. There's some current landscaping there that would have to be beefed up and with the addition of a screening fence. Looking due north at the church property and looking more towards the west, you can obviously see through the west property line, and that fence would have to be upgraded to a solid screening fence. Just more shots around the property of the vehicles that are currently stored on site. And with that, I can stand for any staff questions you have.
Any questions for staff? Mr. Richardson?
Couple of questions, Philip. Is the staff recommending approval based on the revised PUD submitted by the applicant with the 6-foot fencing and the changes that they've made? Is that
Yes, our recommendation does not take into consideration the recommendation from the District Advisory Board, since that just happened. We were submitted the revised documentation with the highlights you have in yellow. Those were the revisions that we received, and that's what is attached to the back of your staff report. Our recommendation is based off of what we received from the applicant and not anything in relation to what the District Advisory Board has amended since.
It also includes what's in green, which is about the access for the duplexes?
No, it does not. That is language that was added after the District Advisory Board.
But you're okay with that language, I would assume?
Yes.
Yeah. The next question is, if this were strictly office warehouse zoning, what would the screening requirements be?
Very similar. I mean, you would have commercial property next to residentially zoned property, so they would have to comply with the landscape ordinance. They're actually 1.5 times with the landscape ordinance. The landscape ordinance would be 1 tree every 40 feet. For the landscape buffer, the screening requirement would be a 6 to 8 foot, either solid screening fence, which could be wood, could be masonry wall, just a fence that's solid screening.
I thought that I had read in the office warehouse where anything stored on site would have to be hidden from view.
From ground level view or from the
By
street.
ground
So
level
they could have
view.
some outdoor storage, yes, but as long as it's hidden from ground level view from all property lines, as well as any entrance into the street.
And
If
how
not, it would have to screen it on property.
how do you know it's been, I mean, if we don't, does that mean landscaping works for a screen even though it's deciduous trees? Or does it have to be, in other
It would have
words,
to be solid screening. So if they use landscaping as their form of screening, it would have to be as effective as a 6-foot solid fence. So it would have to be evergreen trees or evergreen, something that's at least 6 foot tall that provides solid screening 365 days of the year.
but my point would be if you have buses parked on this property and if you were going to screen them, you would need a much higher fence than 6 feet.
Right, if they can see it from ground level view from any contiguous property line, if it was OW zoning, it would have to be screened.
But we're not requiring that in the, at least in the PUD, it is
No.
not. We're saying you can handle that with screening?
Right.
Okay, thank you.
Mr. Foster?
Philip, if this is not approved, what would be its zoning status, given the confusion that we've been presented with?
It would be
And what
single family,
uses would
yeah, it
there
would be
be?
single family SF5 with the provisions of the conditional use that were back in 1974, which I read allows for an agricultural storage building for storage of alfalfa hay, farm equipment, and non-agricultural storage, including earthworking equipment, including trucks, tractors, and miscellaneous. That's text taken straight out of the conditional use.
And would the conditional use require the landscape screening of some form?
I might defer to Scott on this. The zoning is still residential, so it'd be residential zoning to residential zoning. I don't know if there's a stipulation on if a conditional use allows more of a commercial use. Scott, do you want to weigh in?
Yeah, actually, what would apply would be the zoning code, which would require screening for outdoor storage. Because it's what the code says within, I think it's 200 feet of residential zoning, outdoor storage is required to be screened.
Mr. Nix?
Philip, I have a question. So when we talk about screening, we talk about evergreen and deciduous, a mix of evergreen and deciduous trees. I'm just curious who determines what kind of deciduous trees we're talking about. I mean, you can have some pretty tall, scrawny looking trees, and you can have some full-grown, wide, in-depth kind of trees.
A landscaping plan has to be approved by the planning department.
So the planning department determines whether it's a maple, an oak.
Right, I don't think we have any stipulations on the variety of a tree.
Actually, there is a pretty detailed landscape ordinance that does require certain species.
Okay. Thank you, Scott.
Mr. Hartman?
Yeah, Phil, so what's the status on the access easement?
Can you clarify status as in?
Like who maintains it? What's it supposed to be maintained? How wide is it? And that kind of stuff?
I believe it's 30 feet wide. I know the applicant or the agent for the applicant can clarify this. My understanding is that the property owner to the east is a sole responsibility for maintaining it. The properties, this property is party to it, meaning they get to have the access, but they don't have any, as of right now, they don't have any responsibility in maintaining it. I think it's 30 feet wide. I'll defer to the agent for the applicant. He has the specifications.
But am I correct in assuming that that easement goes all the way out to Maze Road and is part of the parking lot for the office building there that faces Maze Road?
I believe so. I don't think it's, I don't think it just goes to here. I think it probably goes all the way to Maze Road.
So that property owner to the west there in the house is required to maintain basically the parking lot for the office building?
Again, I'll defer to those who know a little bit more about the details of that access easement. I apologize, I don't have that information.
Mr. Richardson?
Philip, I think the other thing about the easement, as I read it, there were no restrictions as to the type of use to which it could be put. I think it was simply an easement, and at the time, at one time, Mr. Kirk owned all those properties, including where those offices are. So this was an easement between related parties way back when. When he sold off the front for those office buildings, I think that easement stayed in place. And pretty much had to in order for you to get to the back of the property. That easement's got to stay there. But I don't think the easement probably ever intended any sort of use, although Mr. Kirk had heavy equipment stored there and he ran heavy equipment over that easement. He had earth movers and other kinds of things there. So, it's one of those things that got done years and years ago between related parties. Everybody kind of understood how it was going to work. Now we have 3 unrelated owners for this easement. And, actually, although I'm sympathetic to all those cases, in our case, we can't really litigate that easement. I mean, we don't have any way to change this easement to say you can only use it certain times a day, or you can only use it for certain kinds of equipment, or any of those kinds of things. That kind of has to be litigated, if you will, between the property owners. And I think that the supporting material here pretty well points out, a fairly lengthy opinion from a law firm that says, yeah, you do have a valid easement, essentially, that says you can get back to your property and use it. So at that point, I don't know that there's anything else we can do about it. It's just one of those things got played forward over the years that started out as a kind of a benign sort of a way because the son wanted to build that house that's now next door to this property.
Mr. Nix?
So at one point in time, that was at least 30 feet because as you said, the Kirks moved a lot of heavy equipment in and out of there. the thing's not 30 feet now. I don't know how it
I
got
think the
squeezed
easement is
down,
30
but
feet. I think the drive is smaller than 30 feet. So you have
Yeah.
a 30-foot easement, but the actual drive lane is
Oh.
smaller than that.
okay.
If there's no additional questions for staff, we'll ask the agent or applicant to come forward, and they will have 10 minutes. State your name and address for the record, please.
Brian Lindeback, MKEC Engineering, 411 North Webb Road, on behalf of the owner and applicant. Given the complexity of this case, I'm anticipating we're going to need additional time, but I'll let you, maybe address that at the appropriate time. I do have the owner here. He would like to make a few statements prior to me presenting a bit of a presentation here.
Thank you. My name is Jason Bayless. I am the property owner. My business partner Nathan and I purchased the property in 2017 to use for our personal enjoyment and to service our small businesses. We store some of our recreational items, including motorcycles and golf carts, in the building. I like to use the shop to change the oil in my family cars and perform routine maintenance when necessary. We also have 3 small businesses that we operate out of the property. The first business is my 10-year-old party bus franchise. I purchased a franchise to operate 6 party buses in Tulsa, Oklahoma. One of my favorite parts of that business is to build the buses I use to rent out. In the past, I've built those buses in my home driveway, and I've always wanted a shop that I could build them in. When Nathan and I found the subject property, I was excited to finally have a place to work out of. The owner at the time, Mr. Kirk, operated an excavation company and had lots of tractors, trucks, and heavy equipment on site. He used the shop to service and repair his fleet and heavy-duty equipment. He did that there for about 50 years. It seemed a natural fit for our much lower-use business to fit perfectly into the space. To date, I have built 2 buses in the shop, and I have 3 buses parked in the gravel parking lot. The second business is Nathan's Pet Waste Removal Company. His business has flourished in the last several years through hard work and excellent customer service. His 2 small trucks go out every day from about 8 a.m. to 5 p.m. and clean neighborhood yards of pet waste so children and families can better enjoy their yards. The third business was born out of the property. Nathan, an avid golfer, enjoys tinkering, so much so that he bought an old golf cart, and much like we do with the party buses, he improved it. After completing this newly renovated cart, friends and family took notice. Several began asking if he could do one for them, and Golf Cart Guys was born. We sold around 30 carts last year, and this hobby turned small business profits very little, but does help cover the cost of the 3-acre property and shop. I hope that paints a better picture of who we are and what we are doing. The conditional use currently in place does not allow for our low-use needs, but does allow for us to operate a large construction business with no limitations on traffic or size of vehicle. I'm hoping that this correction in zoning gives us the ability to continue our small business operations. I would like to thank the neighbors who have stepped forward and voiced their concerns for the property. As lifelong Westsiders, we appreciate that others care about the community too. The insight has given us an opportunity to improve our property and address some of the needs and concerns of our neighbors. Nathan and I are looking forward to bolstering the green space recommended to us and to continue to improve the property. Thank you.
Good, Jason. I think everybody's seen the property, understands it. Probably one thing I'll mention is that, obviously, I think everybody knows this. If you read through the history, that all this property was owned by the Kirks at one point in time, and the city has developed around them. And in fact, they were annexed in 1999. This property, the subject property, has never functioned as a residential property ever. It's always been either a field for agricultural use way before they used it, and then it was used for their business. So I think that's an important point to note. Is everybody bought their residences with this property in the back, and it's just continued to develop around it. I think that's an important thing to note, that the access easement is 30 feet wide. It's shown here. It was in place since the 70s. This property was then sold to an individual. Whether they're family or not, I don't get into those details. I know it was sold to a different individual, and at that time, it was granted that there would be access through this property for the business, and also that this residence would have to maintain it. I do have Robert Smith with Folston Siefkin here. He will answer any question you have regarding the access easement and its details. I'm not going to get into the details of it. I think he's better suited for that. I've already talked to you a little bit about the history, and just some dates to note. That the first access easement was granted in 1986. Later on, the excavation business owned that property to the east. Of course, property was developed around it in the 90s. It became annexed in the city of Wichita in 1999. I think most everybody knows that when you become annexed, you get single-family zoning by default. Of course, that conditional use was on the property prior to annexation. The property at the front was developed with offices in the early 2000s. Of course, the church was built just right to the north in the early 2000s. I think staff did a great job of explaining the case. We are in favor of staff approval. We are in favor of the staff report. Appreciate the comments that was made about the zone change. I think that is very relevant, just knowing that we've been through here in the past, and we're trying to rectify the past problems by actually getting this zoned properly for the future use of this property. I think we've all heard what businesses go on there, and we intend to keep that low impact with how this property is operated. One thing to note is that we've got cameras on the site, and that for security purposes, and we've monitored it over the past few months, and we've averaged 8.6 trips per day in and out of the property, and I think that just speaks volumes of the fact that there is such a low volume access to the site. So DAB, we've got these PUD provisions. Everybody knows that the provisions are there to protect the neighboring properties and to allow for orderly development in the city. We've heard the DAB, and we've limited the very northern part. I'll show you a slide on the next slide, which is we've limited the northern part to less than an acre of equipment sales, and we're not going to do retail sales in that area. Certainly, we're in the business of selling golf carts, so we can't just explicitly say we're not going to sell vehicles, and we're in the explicit business of rehabbing buses. So it's difficult for us to say we can't do that, but what we are willing to say is that we're not going to have outdoor sales of any kind of lots or anything like that. So that's what we've done here. We heard the concerns about the duplex. We thought it was reasonable to prohibit duplexes in the event that a secondary access is gained. I think that's reasonable, and it just definitely preserves the development options in keeping with the residential components around it. Landscape obviously is critical. Trees grow taller than fences. A fence is 6 foot to 8 foot. A tree will grow much, much taller than that. We're intending to put roughly 40 to 50 trees on this site as a landscape buffer. That's what this means, the 1.5. That's a significant number of trees for anybody. Those trees will go taller. They're going to screen the property, not just at the 6 foot level, not just at the 8 foot level, but beyond that. So as you can see, we've got all these other restrictions. I think those are all very important restrictions. I think it's very also important to note that the site has no access visibility-wise to the arterial street. It's very hidden. That's good in certain aspects for this type of zoning. It does not have signage on Mays Road. So to me, you think about, well, you're going to run some sort of retail, car sales out of here. You're not going to. It's not practical. This is the area that we're talking about of restricting outdoor use operations. It's a very significant area reduction. As you can see, there's some existing trees on the, hopefully that shows up on there. There's some existing trees out there. We're going to bolster that and increase that landscape buffer. We, again, just want to emphasize that trees are going to do much, much better. We're going to maintain them and keep them so that they do screen from the properties. These properties have been here since the 90s, and there's very little trees from the south, and there's very little trees to the west. There are a lot of trees on this residential property that screen from the neighborhood office. There weren't any trees here. All these property owners bought this property in that fashion. I just want to make it known that we're going to increase the landscape and make it beautiful from that perspective. we aren't wanting to do residential here, but I think it's important to visualize and contemplate what that would look like from an access standpoint. One of the most unique sites or interesting things about this property is that its access. And that's why we have it as a PUD, because it's a landlocked parcel here without this private access drive.
Ryan, your time's up. How much time do you think you need to?
If I could have 2 more minutes, I think I can wrap
For
it
a
up.
motion for 2 more minutes?
Thank you very much.
All in favor? Got 2 minutes?
Thank you. Like I said, we aren't looking for non-residential, but with this sort of pattern, that could be very likely. We'd be looking at roughly 120 trips per day with 14 households, and that's based off of the DOT standards. I think it's really important to acknowledge that there are existing conditional use, and we think that this use with this PUD would be a better use and a better fit for the neighboring properties. I've just reiterated these photos. Here's the site. It is a 30-foot easement across the southern 30 feet. There is, it shows multiple cars on the residence next door, and their access drive to the south, to the north here along their property line. There's, of course, the business. You've seen those photos. Let's switch back here. This is the new gate that was installed. These are some of the things we've heard from the neighbors. I would like to mention that I've contacted the adjacent owner a number of times, at least a half a dozen, if not more, left messages, persistently trying to get a hold of them since our meeting, and they've refused to meet with us. These are some filling that was done in the driveway by our client, some additional signage, of course the keypad. And I think the main thing I want to emphasize here is just that these are going to be enforceable rules on the property, and it's going to be very compatible with the neighborhood, given the new provisions that are in place. I just think there's a unique parcel of land, and it requires a unique solution. And I think this is should be an approval. Lastly, I think if we don't approve this, we're asking these businesses to vacate, and it'll be forced to go back to what it was.
Questions for the agent? Mr. Hartman?
Ron, you mentioned that there would not be any signage on Mays Road.
There's no
There's
signage to the property on Mays Road.
I believe there's a Kirk Excavating sign that you can see as you go down Mays Road.
Yeah, we don't have the ability to change that out.
Who does that belong to?
It's not on a property that we own nor control.
Mr. Green?
Yeah, can you explain the electronic gate that they have at the entrance into that property? And I guess there was some concerns that the code was not known, or there were some issues with that. Do you have any?
Yeah, I mean, they have a code system, and Jason, he's available here if you want to ask him specific questions about the code system. I don't know if it perhaps could even be opened with a garage door opener. They're shaking their head, yes, it can be opened with a garage door opener. So certainly with the low volume of vehicles going through here, I don't see that at all being an issue from a standpoint. There may be a rare occasion where someone parks there to get access, but that is permissible. It has an access easement.
I just know that that was one of the main concerns was brought to us the last time, is that they weren't able to get out. They weren't able to, my voice isn't able to get out either. They weren't able to, they weren't able to get out of their driveway because there were vehicles blocking the way. And I understand if there are 6 to 8 trips on a daily basis, depending upon what time of day, I guess it could be an issue, but I think any way that they can improve the access to that property, which it sounds like you have done.
Yeah, we have.
It would be very helpful.
Okay, any additional questions for the agent? Thank you.
And just remind you, we do have the attorney here that can answer any questions
That's my
pertaining to
question
that.
for the commission. At this point, normally we would go to the, anybody from the audience, but you have any questions for the attorney regarding the easement before we do that? Or are we ready to go to the audience? Mr. Foster?
Just one question. I've read all this information Mr. Smith put together, and basically there's no solution relative to the maintenance, but it's a non-issue for what we're talking about?
Yes, I've read the letter, agree with the legal analysis, and I don't know how you can do the maintenance of it.
At this time, we'll open up the floor for anybody from the audience that would like to speak on this issue. If you do, state your name and address for the record, and you will have 3 minutes.
My name is Amber Hemmen. I live at 1905 North Maze. I live at the property that's just adjacent here on the east side. In regards to what Mr. Lindebach said, the average of 8.6 vehicles a day over the last couple months, you got to take into consideration that those volumes increase significantly through the spring, summer, and fall when camping and boating season are in session. I have some current pictures of, you can't even see all of the campers and boats that are stored there, and they do go well over a 6-foot screen. Let's see here. And this is just this picture right here. This was taken on December 13th, even with the keypad. So people will pull up, like where that truck is, they'll enter a code, still blocking our drive, and then they'll sit there until the gate opens. And like in this instance right here, this Jeep, he wasn't able to access the gate, so then he just pulls in and takes my son's parking spot in my own personal driveway. This is very frustrating, especially when I have 2 teenage, or well, soon to be 3 teenage drivers in the home, and my husband and myself, we each have our own parking spots, so that way we can come and go as we need and not play do-si-do with the cars. So this is just current pictures. The pictures that Philip presented that he said he took in November were not taken in November. Those were taken well like a year and a half ago. One of our cars that was in the pictures, we got rid of several months ago. So those pictures were old. These are current pictures of the trash and the dump truck that Mr. Lindebach claimed that the owners did not have at the last meeting when one of the other neighbors mentioned that dump trucks go through there. So anyway, I just feel like maybe this is spot zoning just because of the fact that it's completely surrounded by residential areas. And the other thing is, and I'm sorry, I'm not trying to jump back and forth here. I anticipate a little more time, but the actual drive, the road is 17 feet wide. My husband just went out and measured it again Monday before the DAB meeting. So unless you're going to drive through our yard or the little grass ditch, you're not going to be able to, you really can't drive 2 vehicles through there at one time. So I know at the last meeting in November, someone had mentioned just using Pathway Church as like an access, and that's what we feel would be the best.
Your time has expired. How much time do you think you would need to?
Could I have 2 more minutes, please?
2 minutes granted.
Thank you. We feel like that would be the best just because that's already paved. The other night at the DAB meeting, one of the speakers was talking about gravel roads and how the capacity for a gravel road is supposed to be the least as far as the number of vehicles. And since our road is gravel and it's our duty to maintain that, I don't know how it's deemed fair for us to maintain a road for our neighbors that have much more, traffic than what my own family has. So I know I've spoke with Dan at Pathway Church, and he's fine with them rezoning. So I think that maybe they could work out an agreement for access. As far as Also, the safety concerns, you can see like this is a fire hazard. I actually spoke with the fire chief, all of these tires right there, and that's about probably 40 feet from my garage in the backyard. All of this, you know, rodents, anything, all of it's a fire hazard. So that does, you know, raise concern for me. Also, if they have a paint booth, we're on well water, so I'm not sure what could be leaching into the ground from anything like that. And it's just scary to think of what we could be consuming in our water. The last thing I will say is I do appreciate Mr. Dooling's efforts into trying to change the fence or the gate issue. I did speak with him after the last meeting. The most appropriate thing at this point is if they're using our access, not to even have a gate closed. Just so that way we don't have any traffic backing up and parking in my own personal property. I mean, we already pay the taxes on that easement.
Any questions for the speaker? Mr. Green?
How long have you owned the property?
We bought it in 2015.
In 15? What was on the property to the east at the time that you bought it? What all was going on over there?
To the east of me?
I'm sorry, to the west, to the west.
The Kirks were no longer in business at that time, so it was a non-operating business. And I had actually spoke with him about purchasing the property, and I also consulted the city to see what we were able to do with the property. And once I was informed of the conditional uses, that's nothing that we had, you know, any plans to do, so that's why we backed off from buying it.
So the property to the west, there was nothing going on there? It was just vacant and
Right.
No businesses, nothing going on at all?
Correct. Kirk he would come and go occasionally. And then probably the last 6 months that he owned it, he was renting out a spot to like a semi-trailer who would park there.
Now, when you purchased it, did you also realize that there was a 30-foot easement on the south part of that property that you were to be responsible for?
I was not aware that we were responsible for it.
It probably would have been in that stack of closing papers that
Well, and
that you get to sign.
The thing is we've consulted an attorney, and on our deed, it shows parcel 1, which is our property, and parcel 2 is crossed off. So the attorney who we've spoke with said that we have the right to block access because now that Pathway Church is there too, they have an alternative.
Okay.
Mr. Hartman?
When you moved in, were the office buildings constructed to the east of your house?
Yes.
Okay.
Any additional questions? Mr. Foster?
If the gate access were addressed, is there a configuration that would improve the condition? For example, let's say the gate itself was moved further west into the property. What kind of configuration would help with your access?
The fence would have, or the gate would have to be set back, I would assume at least probably 100 feet, just because like during camping season, for example, we'll get 4 or 5 trucks with their campers or boats lined up along our driveway, blocking us. So considering the average length of a vehicle is about, 15 to 20 feet, I think 100 feet at minimum would be reasonable.
Just another question. One of the challenges when you look at these cases is the reality that if you do nothing, it can be a worse condition. So my question is, given the PUD application here, I'm thinking of the landscape buffering and restriction of the uses. Do you see that this is a step towards an improvement for this property relative to the area?
To have the area rezoned as a PUD?
Which has this protective overlay of restricting the uses and the buffering, And I think it would do a better job of addressing the environmental things you brought up as well.
I don't know, I personally think it's a step backwards, just because they've already been operating for almost 3 years like this. And, you know, so, I mean, in my opinion, if they've gotten away with it this long, what else can they get away with? And, I mean, for example, when I'm told that there's gonna be 20-foot, you know, screening, the trees are gonna be 20 feet set apart on the south line property, but only 30 feet on my adjoining property line, then I'm not sure. I mean, deciduous trees will take several years to actually grow together and provide a screen anyway.
Additional questions for the speaker? Mr. Florence?
That debris on the back, how long has that been back there, those tires and this other stuff?
That's been there, I mean, well over a year. We have multiple pictures, I mean, from even the spring of 2019.
Have you seen an increased rodent problem in your house?
Yes, we have 4 cats, and they are always jumping the fence and bringing mice back over. And I know we also have seen an increase in possums and raccoons, so.
Any additional questions? Thank you. Anybody else in the audience wish to speak on this issue? Come forward, please state your name and address for the record, and you have 3 minutes.
I also had pictures. I'm not sure how to. We're back. Okay. Good afternoon. My name is Mary Taylor, and I'm this property that the mouse is pointing at to the south.
Your address, please.
It's 1872 North Lark Circle.
Thank you.
We bought the property in 2006. At that time, Kirk Excavating was behind us, and that was one of my concerns that I called the city about. At that time, I was told the zoning was residential, with the exception that Kirk had been grandfathered in so that their business could continue to operate, or a business exactly like theirs. Since the property has changed over, there's been a definite change in the neighborhood. I never had any problems with Kirk Excavating, never had a call about a complaint, because they would take care of their property and their things. This is a picture of the fencing that's been down for years. It was actually on our property for over 6 months. The 2 panels had fallen. So we're talking 12 feet of fencing. So it's a very obvious thing. This is the obnoxious weeds that are allowed to grow. We've seen an increase in fleas, rodents, possums, all the animals that Amber talked about. More pictures of the weeds. After the fencing had lied on our property, you can see there in the front where some of our grass died off because of it. My husband finally had to move it, and so he propped it up, trying to make it more obvious for him, hey, there's still some fencing here. And again, just more pictures of all the weeds. They actually grow so tall, you can see it clearly from our backyard. They grow into our yard, and there you can see the property line with them in back. So they say integrity can be measured by what you're doing when no one's watching. When no one's been watching, this is what's been going on for years. As I mentioned, since they've taken over ownership, there's people coming and going all hours of the day, noise all hours of the day. Golf cart racing is taking place back here. It's a golf cart track. Fleas, rodents, all sorts of animals running into our yards. The owners have ignored multiple times. I've tried to contact them to help rectify this. The first time I heard from them was Monday, after Monday's hearing. And then all of a sudden they wanted to play nice and be friends. I just ask you to think about,
How much time do you need?
I believe I only need another minute.
1 minute. Go.
Okay. Another thing, my husband does have COPD. There's neighborhood daycares, and there's also children that often play in this area. So a lot of the PUD and the openness of that zoning scares us, and the health conditions that may come because of that. I'm just asking you all to think about these pictures you've been shown. Would you want this to be your neighbors? We're not asking for anything new. We're asking to actually correct a wrong that's been allowed to continue for 3 years. They've been operating illegally as businesses. It should remain its original zoning.
Any questions for the speaker?
Thank you for your time.
Mr. Richardson?
When were those pictures taken that you've shown us there?
These were from the spring of this year, but it's been this way the summer before also, and I have a phone here, older phone, I could bring them up and show you.
Thank you.
Any additional questions? Seeing none, thank you. Anybody else in the audience wish to speak on this issue? State your name and address for the record, please, and you will have 3 minutes. Please, yeah, wait a second. Thank you.
Dan Dorflinger, I'm the facility director for Pathway Church, the adjoining property to the north and the west. I'd just like to state a couple of things regarding this property. We have been in communication with Nathan. We talked to him when he did move in next door and bought the adjoining property. He has been responsive to requests that we've had. I think it was Mr. Foster who had asked about a steps towards improvement. And I would say that this PUD, in our opinion, would be a step towards improvement. When Kirk Excavating did own the property, it was kind of that lull in between when he stopped practicing and before he sold the business to Nathan. There was a pretty good chunk of time there where the property was definitely in disarray. The fence that you saw in some of those pictures to the north of this property, which is adjoining our property, the fence was in total disrepair, and at our expense, Pathway Church actually replaced that fence on our own dime just because we needed a buffer between us and them. So to have that fence taken over by another property that would keep it up would be in our favor. We have talked to them about a possible height increase on that fence. At this time, the fence is not in disrepair. It is in good shape, so we are okay with leaving it as is. And I've talked to Nathan, the owner, about increasing the height of that fence if needed to be replaced in the future. They've been very responsive to the requests that we have made, as you can see in the changes they've made to the PUD in terms of the landscaping buffer, the fencing to the west side. I'm trying to think. Yeah, so I would say as far as a step of improvement, it is definitely a step of improvement to approve this PUD and move forward. And I think it would be in our best interest as the church as well. I think that's all that we have to say about that. Any questions?
Any questions for the speaker? Mr. Hartman?
Yes, have you had any discussions with the property owner about providing access from your drive into the property?
We have. That we have not ruled that out as a possibility in the future. Currently, in our given situation, we're not ready or willing to do that, but in the future, that may be there may be an opportunity for that.
Would the church ever be possibly would they possibly purchase that property for maybe some church housing?
That is a possibility. We have talked to Nathan about that possibility. If we determine we do want to develop that property to the west of that property.
Mr. Richardson? No? Okay. Any other questions for the speaker? Seeing none, thank you, sir. Anybody else in the audience wish to speak on this issue? Seeing none, let the agent come back, and you will have 2 minutes for rebuttal.
I'd like for you to hear from Robert Smith regarding some of the comments that were made about the access. I think it's critical to understand that.
Hello, my name is Robert Smith with Folston Siefkin. Address is 1551 North Waterfront Parkway, Wichita, Kansas. So I just want to address quickly some of the comments that were made regarding the access and the parking of vehicles on it. And I think there was two different kind of parking scenarios that were thrown out there. One would be the parking of vehicles temporarily on that 30-foot access easement, which I know the road's less than that, but they can park on that 30-foot access easement temporarily while they're making use of the access easement, which would be opening, closing the door. It wouldn't be parking there for, a day, but while the easement grants are generally read to allow you to make whatever reasonable uses that are needed to enjoy your easement that you've been granted, which would include being able to get out and open and shut a door. It would not include any right to park anywhere off of that 30-foot easement area. So that wasn't addressed, but it was mentioned, and it sounded like that may have been off the 30-foot. And then, that's something that I'm sure that they will be more than happy to address to try and stop from happening. The only other kind of comment, feeding off of I'll do it quick, is that the easement that she referenced on their deed that was X'd out actually isn't to our property. It was their easement to the grant's easement and access to their property over the offices. So if that's invalid, it would be a problem for their access, not for ours.
Is that enough time, or you need one more minute?
That's all the time I need to address the items I was going to talk about, but I'm sure Brian,
I'll give you another minute.
Thank you very much. I think, just to recap, with regard to screening and fencing, our client has been out there and repaired that fence that was displayed earlier as of, I think, within yesterday. So I think there's also some miscommunication that occurred. While it may seem funny to some people, it doesn't sound like there was actual contact ever made between the two parties. So when you leave messages for Kirk Excavating or other businesses that aren't related to this property, you can't claim that you tried to get a hold of them because you called the wrong number. So you can't say that. So I think it's important to understand that, physically going over and talking to your neighbor is important. But yes, we are in agreement to increase the landscaping on this property with approval and to rehab that fence and maintain it appropriately.
Thank you, Brian. Any questions for Brian? Mr. Richardson?
I need to disclose I've had ex parte communication on this. Brian, would your client be willing to inset the opening into his property, inset that fence, that gate by, say, 50 feet, where people could park there on his own property while they're waiting to get in?
I would have to ask them, but I don't think, practically speaking, I think they have multiple garage door openers for that gate and they've got a key card system. I think it's what we're doing prudent things here to improve that situation. Certainly there's going to be case scenarios where that's not ideal, but I don't think, if I would read them correctly, I wouldn't necessarily think that would be appropriate. We've got access rights to her land. I think that's what, we need to exercise our access rights.
Well, yeah, I understand that, but if we're going to have retail sales here of golf carts and other things, it's just going to happen that people are going to show up there wanting in that gate and they can't get in for whatever reason. And, they don't know that the access is limited to 30 feet, so they could easily park. Looks like a compromise here is to simply inset that gate by 50 feet. If you got people showing up with cars and boat trailers, that stuff just happens. I get back from Table Rock Lake, it's 3 o'clock in the morning. I'm liable just to leave it there and come back if I'm trying to put my boat there. And so, that's a question that I have if your client would be willing to do that. And I guess your answer is no.
Well, I can certainly bring them up here and ask them directly, but to me, I think they have legal access rights. They're exercising them
I'm not denying
diligently.
the legal part of it. I'm just asking if he's willing to do that.
Yeah, I hear you.
Mr. Johnson?
Yeah, how does a car that comes up there, how do they turn around to get back out if the gate's locked?
They enter the structure. Everybody that's coming in and out of property that has legal rights to that property has knowledge of the key code as well as the clickers to get in and out of the property. I think it's just like any, if it were any other dead end, you would have to back up and make a 3-point turnaround and get out of there. But it's a 30-foot access easement. Your car is definitely not 30 foot wide, and it certainly could turn around and get out of there.
Additional questions for the applicant? Mr. Green?
Yeah, Brian, it's a 30-foot easement, correct?
That's right. It's a 30-foot easement.
How much of that easement is actually being used for the drive?
Well, I think I don't disagree with what she's saying is 17 to 20 feet. I'm sure is being utilized for the access drive. We do have rights to 30 feet.
So technically that access could be 12 to 15 feet wider.
Precisely.
Which would eliminate all the issues that we're seeing with the use of that access road.
It would also reduce potentially use of her property that she's enjoying now.
Additional questions for the applicant? Thank you. Bring it back to the commission for discussion, recommendations.
I've got some discussions.
Mr. Hartman.
I'm pretty familiar with this property. I've driven by it for many, many years. And even when it was Kirk Excavating, I just thought that was kind of a weird, strange use right there off of Maze Road being back in there. But knowing that the owner lived there, I could see how the use could evolve and start out. But it was primarily used by the owner for housing his excavation equipment. And now we're looking at several different types of commercial uses here with terrible access. Maze Road, in the meantime, is a very busy road. Getting in and out of Maze Road is not easy no matter where you're at. And I just think a commercial property here in the middle of residential zoning just does not make sense in this case, even though it was an existing use and it may just sit there for a while. But I think in the long run, I think this could possibly be used for some housing that the church might be able to make advantage of. So I'm going to be voting against it.
I'm going to take a opposite side of that. Frustration that I've always had with properties that have been zoned and used agriculturally and cities grow up around them and take them in, that everything automatically comes in as single family when that's not what it is. This property has been used in some method other than single family for forever. And so to take away the right of individuals that have had a property, that have had the use of it, I agree with Mr. Foster here that coming up with a plan that improves the use and delineates the uses and the restrictions of it, I think makes a lot of sense. And I think that we've tried to come up with as many compromise situations, and I think that the applicant has made an excellent effort to come up with something that is viable for a mixed use in an area where that property was used that way first is viable and only fair. Mr. Richardson.
Philip, the neighbor who spoke about the weeds and so forth, can you explain what she could do about that, how to report that, how that could be taken care of?
Yeah,
fall down.
I apologize.
Go ahead.
Complaints can be submitted to, I believe it's, I'm blanking on the name. It's neighborhood control or something like that. But we can definitely resource her with the proper contact information to how to report noxious weeds and other nuisance complaints of that kind.
That'd be helpful for her to know. She has a right to report that. And she says she has reported it and nothing goes on. So you have your city council person in the room. You probably should talk to him if it doesn't get done.
Mr. Foster.
Got a perhaps legal and a staff question, and I've got a couple other items. Does the issue of discontinuance of use come into play on this? If Kirk Excavating shut down for a year or whatever, I don't know if that's in Wichita zoning for discontinuance of use. How does that play in?
Well, the use that is, of Kirk Excavating was granted a conditional use, so it's a permanent property right. So, if they were to operate what the conditional use allows them to do, they could do that in perpetuity, regardless of whether they're vacant or not.
It would be a non-conforming use that could possibly go away from non-use under circumstances that.
If it were non-conforming, yeah,
Correct.
okay.
Well, that would be true if it were a legally established non-conforming use. The uses on this property are non-conforming, they're just not legally established.
Okay, now, please continue on your thought, and this is another question is, if we do nothing, we disapprove this, what uses and activities are gonna be allowed to continue?
It'll be the uses that are permitted by right in the SF5